matters that we need to resolve outside the presence of the jury?
Your Honor, at this time, I would move the court to reconsider Mr. Masucci as an expert witness in our case in chief. At this point, I think it's clear that the state is going to be introducing additional technical information. I believe Mr. Masucci was candid. He was quite direct about responding to any concerns or questions. I think that the data set that he has operated from is one that essentially originates with the FBI and as such is inherently reliable, at least for these purposes, as being what the FBI has provided. And it clearly cuts to the very heart of this particular case in that the inculpatory material that exists exclusively in digital form. And if there is, I'm aware of other case law, and I think that Mr. Zellinger cited some, where the defense had clearly, intentionally withheld expert information, kept experts off their witness list, not turned over reports, and under those circumstances, the court sanctioned the defense and kept the expert from testifying. And in that situation, it was certainly upheld, and it was noted that given the extent of the defense's complicity in this deception, that such a dramatic or drastic sanction was really appropriate. In this case, we're in our 9th week. We have done everything within our power to provide the information that we've received as soon as we have received it. We've done, frankly, the only reason we were able to get Mr. Masucci is that he immediately contacted us and said, this is a case that deals with digital forensics, and it's going to set important precedent, and I don't want to see it happen without an even playing field. And Judge, I'm asking the court to please reconsider its ruling on this particular matter. I think that without the ability to effectively address digital forensics evidence that has been presented against Mr. Cooper, that he is unable to present an effective defense.
You already heard.
I don't, Your Honor. We're in the same position, except today you heard that Mr. Masucci hasn't even finished his not investigation, his research into this case. So the state, again, is prejudiced. Additionally, I'm not in a position where I could offer, there's a time where I might have been in a position where I could have intelligently cross-examined him, but at this point I have a 3-page report, and I can't cross-examine him on his report because he's not even done with it yet. So there's definitely prejudice that's befallen the state. Additionally, Your Honor, the only other thing I'd point out in relitigating this issue again is state, I don't know why those folks aren't being called, but the fact still remains that it's inherent upon the defense to give us notice of these experts so that, and the state, for both parties, to give notice of expert before they are called so that they have an idea of who the person is, so they have their resumes, so they know what the person's, where they, the ability for them to testify to their expertise, and something meaningful so that we know what they're going to testify to, and we don't have that from Mr. Masucci in this instance. And to go back on the court's ruling earlier would actually prejudice the state further because we no longer have the ability to cross-examine Mr. Masucci based on the report that we haven't even received. The only other thing I point out is, well, I'll just leave it at that. I think it's clear though that there's a huge prejudice that's befallen the state at this point, and without having notice, which is required by these general statutes and the rules of evidence, we are prejudiced. And because the defendant failed to do that, we're the one that gets that prejudice. And based on that, Mr. Masucci should not be able to testify.
I would just like to add, Judge, that the state has recently received information that they intend to introduce in their rebuttal case. It is information where we don't have a formal report yet. We're just getting dribs and drabs in as they get it, but truly just getting it in little pieces where we're going to have to deal with the exact type of prejudice that Mr. Zellinger is worried about with Mr. Masucci. And so I think that we're now on a much more level footing in this argument, in that we're all going to have to adapt to new information quickly, and probably we're not all going to be as artful with it as we would like. But the bottom line is, this case has been under investigation for over 2.5 years, and they are still getting information that is not their fault, but it's something that we're going to have to deal with. And I don't think that prejudice that will befall us is any worse than whatever prejudice might befall them, having to deal with essentially the same report that they've had for quite some time.
The only thing I would say, Your Honor, is that Mr. Curtis is asking you to speculate on what the state is going to do, and what the defendants received is discovery from the state as we receive it pursuant to the requirements of 15A 905 and the open file discovery rules. Those are totally different situations, and if we get to that point, we can cross that bridge. But just because I've provided discovery to the defendant on things that I've received, I don't think puts us in any different situation than we were before Mr. Masucci.
We actually did get notice from the state that they intended to introduce a new witness, and Chris Fry as an expert witness.
He's already on the witness list.
He testified, and they already have his resume and had his resume before this trial started. Additionally, I'm not sure he needs to testify as an expert witness, but if I'm going to be punished for going out of my way to put myself in a best position weeks later, then this is a completely different issue. But it's Chris Fry. Paul Giroux might be testifying as well, who is an expert witness, who testified as an expert witness, and Greg McLucci is another person involved in this email string who's already testified. All these folks have testified, and their information is out there already. It's a completely different situation. I mean, the defendant doesn't. This research and investigation started last Thursday, and it's not even done yet. So to allow him to, it just seems to me like there's incomplete data at this point. And that I don't mean to belabor the point, but he's not even done yet.
And neither is Cisco with what they're doing, and neither is their ornithologist that we got notice of just recently. So there are new experts flying around, so to speak.
But until they get ready to land, it's really not an issue for me to deal with. So your objections, I think, are a bit premature, because at this stage of the dance, they may not even offer rebuttal evidence. They may be telling you that to see what's going to happen.
Judge, I wasn't saying objection. I didn't object to what they're saying. I'm simply saying...
No, I know, but what I'm saying is that we may not even get to rebuttal evidence. I mean, so to project what they're going to admit through whatever witness or not, I think is a bit dangerous. And I have to look at each individual witness in each stage independent and apply the law. At this point in my discretion, the motion to renew the motion to allow the testimony of Mr. Masucci is denied. Just for the record, I'm going to indicate that the failure to comply with 15A 905, and the defense has not established a good faith basis upon which, or showing that the witness should be called, and also under Rule 403, as I stated the other day.